Hello and welcome to another presentation. In this presentation I'm going to go over property rights in Ontario. What you need to know when they come to bother you. Many municipalities are creating clean yards or similar bylaws in order to clamp down on homeowners who have unplated or expired stickers on vehicles on property. Provided the vehicle is complete, they have no right to make any claims against the motor vehicle on your property. That is to state that if the vehicle is assembled and it has all its parts, or at least it appears to have all its parts, the municipality has no authority to tell you what to do. I have already confirmed this in the court of law. The City of Belleville, Corporation of the City of Belleville, illegally and unlawfully tried to facilitate a criminal activity through a court, and I told them in advance that they were breaking the law. I showed them the sections of the law and they didn't care. This means now that the municipality, the Corporation of the City of Belleville, and the city solicitor, which works for Templeman LLP, are in fact breaking the law, committing fraud on the court. If you're in a similar situation, I suggest you review this document carefully, pause it, record it, take down notes, and do what you need to do to present your case. You are not a free man on the land, as they will claim. What you are is somebody who is following the law, and I suggest they do the same. When the municipality breaks the law and the court facilitates this action, they are aiding and abetting criminal activity. At that point, the court has no jurisdiction. It loses its jurisdiction when it operates outside the law. Many people have been bothered by various municipalities, and I've had enough. I'm making this public knowledge because I put up with it for 38 years. First with John Vance, and then most recently with the current bylaw enforcement people, and I've had enough of it. What they commonly do is they designate your vehicle as derelict. So let's look up the word derelict. Derelict is an abandoned, especially by the owner or occupant. Run down, such as a derelict neighborhood. Lacking sense of duty. Neglect. Okay, well the city neglects their duty because they don't even follow the law. In fact, the municipality of the City of Belleville has parked a dilapidated truck in a park claiming it's artwork. So we know what they can do. Now, derelict is also defined as forsaken, abandoned, cast away, derelict property. Okay, lacking sense of duty, breach of a legal or moral obligation. The city falls into that. The managers were derelict in their duty. Well, the city bylaw enforcement officer, as well as the courts, as well as their officers or their bosses, are all derelict in their duty. Derelict, personal property abandoned or thrown away by the owner with no intent to claim it any longer, such as a ship deserted at sea. Well, if you have a vehicle parked in your property which does not have plates but has all its parts, then I would suggest that that's not a derelict vehicle. In fact, it may be a vehicle you're using for parts to fix up another vehicle. And there's nothing wrong with that. Don't let the municipality tell you otherwise. The municipality does not have the right to regulate the licensing and parking of motor vehicles, pursuant to Section 50 of the Municipal Act, which I've included here. Reads as follows. Section 50, Municipal Act, clearly states that a municipality did not have the power to pass a bylaw establishing a system for permits on motor vehicles, trailers. Those terms are defined under the Highway Traffic Act, similar to a system under Part 2 of the Act. Well, this also pertains to trailers on your property. Recently, the municipality of the City of Belleville fraudulently tried to pass a bylaw regulating the length of trailers on your property. They were targeting boat trailers, but they did not restrict it to that. And there was a public meeting which was conducted, and many people objected. Well, don't forget that the municipality is your elected official. If they're not operating within the confines of what you request them to do, then they are not performing their duty. They can't just simply pass a bylaw because it suits them to generate additional revenue. Now, in my case, I presented my case in court. I gave them 6 precedent higher court cases. I gave them at least 50 violations within the law. and the judge didn't care. Her name was Ryan Bell. Now, some may argue that I am potentially opening myself up to a lawsuit. Well, I'm telling the truth, and I've got the paperwork to back it up. The truth shall set you free, theoretically. Now, the municipality does not have the right to regulate the parking of motor vehicles pursuant to Section 63(1) of the Municipal Act. The licensing and plating of motor vehicles falls under the Highway Traffic Act, which has no authority on private property. I confirmed this with a telephone conversation with the Ministry of Transportation, and they clearly state that a vehicle that is not being used on the road does not require license, insurance, or anything else. Therefore, the court has no authority to overrule the statute, and therefore the court has no authority to do anything, neither does the municipality. If they want to break the law and you point this out to them, then they're knowingly breaking the law, and you have a legal recourse to potentially take them to court or simply tell them to jump in the lake. Now, impounding of motor vehicles on a highway. Remember, your vehicles are not on the highway. They are parked in your private property. Section 63, if a municipality passes a bylaw for prohibiting or regulating the placing, stopping, standing, or parking of an object or vehicle on or near a highway, it may provide for the removal, impounding, restricting, and immobilizing of objects or vehicles placed, stopped, standing, or parked on or near a highway in contravention of the bylaw, and subsection 170, sub 15 of the Highway Traffic Act applies where necessary modifications to the bylaw. Well, remember that says on or near a highway. Your private property is not on or near a highway. Exception, subsection 1 does not authorize any action with respect to a motor vehicle on a parking lot or land not owned or occupied by the municipality. So they have no right to regulate your vehicles on your private property. If the municipality has bothered you over 1 year ago on a similar issue and nothing was done by them, then you are protected under Section 36(8) of the Building Code under the limitations period and under Statutes of Limitations Act, limitation period. Section 8. No proceeding under this section shall be commenced more than 1 year after the facts on which the proceeding is based first came to the knowledge of an officer, which would be the chief building official, where the proceeding in respect to enforcement of bylaws passed under Section 15.1 or the chief building official in any other case. Therefore, the municipality has no authority to bother you if they didn't say anything within a year and they knew about it. Your job now is to keep track of your paperwork to prove this situation exists. If the court operates outside the law, you can simply tell the court to jump in the lake. Clearly, when they operate such a way, they're violating Section 17 of the International Covenant on Civil and Political Rights, and guaranteed under Section 26 of the Canadian Charter of Rights and Freedoms, which reads as follows. Article 17, no one shall be subjected to arbitrary, unlawful interference with his private family, home, or correspondence, nor to unlawful attacks on his honor and reputation. Everyone has the right to protection of the law against such interference or attacks. Now, you'll notice here I stated the Canadian Charter of Rights and Freedoms. Well, there's some debate on that because that's a government rule, and therefore it would apply to the government. Same as the Building Code Act, or the Municipal Act, or the Planning Act. Those are all acts and statutes which apply to the municipality and don't necessarily apply to you. So if they want to break the law, and the law is supposed to be applied equally, you're not a free man on the land when you simply quote their laws going back to them. Simple as that. Samantha Short, and that's the bylaw enforcement officer, as well as Brett Forrestal and the other lawyers that work at Templeman LLP, Jennifer Savini being one of them, should clearly read the law and comprehend it, not try to push through some sort of fraudulent crap and then get the court to try and push it through, because the court has no legal authority to act as a defendant for the municipality. In fact, the city solicitor, Jennifer Savini, stated, I didn't attend a court hearing, and when I went to the court to prove my case, They said they couldn't prove it, which I did prove by contacting Zoom, and that brings up another point, that the court should not have been held in private. We both know, and we all know, that there was no such intervention, that they locked down the whole country. So that's illegal. Now I'm using international law so that I can use this international claim now in an international tribunal. Now I'm only bringing this information forward because other people are probably in similar situations, and there is a video on my YouTube channel where I specifically talk about city bylaw. Further, if you are being bothered by the municipality because they passed some new bylaw, you would probably be classified as legal and non-conforming if your vehicle was on that property prior to them pushing through this fraudulent bylaw. If the municipality thinks its bylaw has superiority over the statute, Section 14 of the Municipal Act clearly states that we have a conflict between a bylaw and a statute. The statute takes precedence to the extent of the conflict. Well, I've shown you now the specific statutes which would supersede the bylaw, which has no force and effect. The municipality will claim it has jurisdiction under Section 15.2 of the Building Code, which is only a half-truth. Section 15 of the Building Code is restricted under various statutes, one being the Municipal Act, and under Sections 9, 10, and 11 of that Act that are limited to what they can do and what they can't do. In fact, there are 74 statutes that I'm aware of that regulate the municipality and its authority. Section 9 of that Act states that municipality has the rights and duties of a natural person. A natural person being a living, breathing human. One person cannot enslave another person, and as such the municipality has no right to force you to do anything on your private property. Absolutely nothing. Now this brings up another point, because we're referring to a natural person. But you should also note that there is a unnatural, or as they call it, artificial person, which is a corporation. Now, this is where we have the conflict, and this is why we have Section 9, because the corporation is a fiction. It's an artificial entity created under the Business Names Act. Now, because your municipality likely has a Dun & Bradstreet number, that also proves that they're a corporation. So they can't have the status of a natural human being because they are not a natural human being. But Section 9 of the Act states that they have this authority. Well, because they have this authority and takes on the role of a natural person, where it says it has the rights and duties. Well, one person can't compel another person to do something against their will, and especially with the threat of force. Such action is not permitted under the law. And you, as an individual, or a natural person, have every right to protect yourself from such infringement. That is the purpose of this presentation. Section 10 and 11 regulate what the municipality has the authority to do. It comes down to the fact that they have the authority over public property and economic development, signs and sewage, and drainage. They have no authority over private property. None. I've gone through the acts so often, I know them pretty much inside out. And the city solicitor is on record stating she doesn't know how to defend the case. In fact, I proved that the city solicitor committed perjury a few times in the one trial, a few times in another trial, and the city bylaw enforcement officer, in fact, committed perjury. 2 of their claims against my property were withdrawn because they were proven with photographic evidence. Now, once perjury is committed in a court trial, for all those that are not aware, once somebody commits perjury, in other words, lies, they have lost their credibility, and anything they say is basically null and void. Perjury is not permitted in any court trial. And I wish the lawyers would learn this, but they don't. Now, Regulation 322.12, which is an extension of the Municipal Act, states the following. Regulation 322.12, under the Municipal Act, scope of local improvements. Nothing in this regulation authorizes a municipality to enter and undertake work as a local improvement on private property without the permission of the owner or other person having authority to grant such permission. So right there they're telling you, it tells you in black and white that they don't have the authority to enter your private property. Okay, simple as that. And they can't do a local improvement without your consent and send you the bill. If that's the case, then I would suggest you get your roof done or your car fixed and send the bill to the municipality. What are they going to do to you? They're going to tell you to take a hike. Well, you now have the authority to do the same. What to do if you're being harassed, or if you're not being harassed yet? The first thing every property owner needs to do is place a gate at the normal entrance of the property. This is usually the driveway or laneway up to the property. The gate should be solid, i.e. not see-through. This will eliminate the municipality from saying some bullshit stating they got a complaint from from a driver passing by. This was the fraudulent garbage that was put through by the city of Belleville, and I proved with photographic evidence that no such view was possible, and I also invalidated the municipality's alleged complaint, proving they wrote it themselves. Such conduct is fraudulent. The municipality is now on record as breaking the law. Now, keep in mind that if you've been subject to this kind of malarkey in your municipality, fraud has no expiration date. The gate should have a clear sign posted on it indicating it's private property. This removes the implied right of access. So I have, this is a kind of distorted picture, but I have a gate in front of my property, which indicates that it's private property. In fact, if somebody violates the gate by going around it or through it, under it, over it, whatever, they're actually in violation of the Trespass to Property Act, and they can be charged. And you do have the right to use reasonable force to remove said person from the property if it's clearly marked. The municipality fails to acknowledge this, and I don't care because the statute called the Trespass to Property Act supports my claim. The second thing every property owner needs to do is place the municipality on notice that your property is in fact private property. To do this, send a registered letter to the clerk's office for your municipality indicating you want it addressed at the next council meeting and put it on record, which they're obligated to do. Send a duplicate letter to the chief of police for your area, be it the local police or the OPP or the RCMP, and to the chief building official for your town. If they ignore it, we don't care, because they were now notified, and if they break the law, then you have every right to enforce the law in accordance with the Trespass to Property Act, which actually is registered and noted in the Criminal Code of Canada, which is a federal law. The municipality no longer has exemption, and they can't pull a hoodwink on you, because this presentation is to advise you of your legal rights. What to do if you are being harassed? Take photos and do an inventory of everything on the property, including, but not limited to, vehicles, boats, material, buildings, construction equipment, or other materials. Make a list with serial numbers and model numbers and replacement cost. Put this in an affidavit format. This way, if they come to take your property, then you can prove it belonged to you. You have every right to take that property back with as much force as is required, or you have the right to use as much force as required to prevent them from taking that property as well. This falls under the Trespass to Property Act. You can do your own research. Now, inspection of property without a warrant. Where a bylaw under Section 15.1 is in effect, the officer may, upon producing proper identification, enter upon any property at a reasonable time without a warrant for the purpose of inspecting the property to determine whether the property conforms with the standards prescribed in the bylaw or whether an order made under Section 2 has been complied with. But keep in mind that the municipality does not have the right to push a bylaw through regulating the licensing and parking of motor vehicles. In fact, they only have the right to deal with public property and certain local boards. Well, we've covered that previously. I suggest you go on the internet and look up those specific provisions. Again, there's sections 9, 10, and 11. Now, if they do issue an order, contents of the order, it says here, an officer who finds that the property doesn't conform with any standards prescribed in the bylaw passed under Section 15.1 may make an order stating the municipality address or local description, that'll be your address, reasonable particulars of the repairs to be made, stating the sites to be cleared of buildings or whatever the issue may be. If the city does not do that, then they have no lawful order, and they most likely won't do it because they want to leave it ambiguous, and as such, they have no legal authority to do anything. You can simply tell them to jump in the lake. Conflict between a bylaw and statute. Okay, we've covered this before. A bylaw is without effect to the extent of any conflict with a provincial or federal act or regulation made under such act. Well, therefore, as I've already shown you, under the sections 50 and 63, they have no right to make a bylaw or any regulation regulating the licensing and parking of motor vehicles on private property. And this is consistent with Section 7 of the Highway Traffic Act. And I called the Ministry of Transportation, had a telephone conversation, which I have recorded, and I have a letter from them that states the same thing. Now, under B, it says an instrument of legislative nature, including an order, license for approval, made or issued under a provincial or federal act or regulation. And since I have a letter from the Ministry of Transportation, that to me is an instrument of legislative nature because it came from the Ministry of Transportation. Without restricting the generality of Section 1, if there's a conflict between a bylaw of a municipality and an act, regulation, or instrument described in that subsection, if the bylaw frustrates its purpose of the act or regulation or instrument, it's of no force and effect. Simple as that. Now, if a municipality or anyone acting on behalf of the municipality does not have the legal right to enter into your living space, i.e. your home. So if a police officer or a bylaw enforcement officer or whatever, or an agent acting on their behalf, tries to enter your home, don't answer the door, speak through the door, and I would not open the door because they could try and force their way through. If they do use force to try and gain access to your property, you have every right to use whatever force you need to prevent that entry. But rather than get into that, let's just not open the door. You are also protected under the Trespass to Property Act. If you put it on the gate, like I said, or you put a sign public that's visible, okay, don't make a little wee sign, make something that's obvious, then you can use the Trespass to Property Act and use as much force as needed to remove the trespasser. If they will not leave upon your request, you get your authority under Section 35 of the Criminal Code of Canada. If they attempt to enter or have entered, ask them for a copy of the warrant or order. When they don't have it, you can refuse them entry. Or if you look at the order and it's not stamped by a court, then they have no legal force. I've also proven by conversation with the local police officers, they have no jurisdiction on civil matters. Now keep in mind that this municipality is a civil contract. So unless there's been somebody harmed or maimed, injured, beaten, or attacked, or raped, those would be criminal activities. So when the municipality tries to enforce their bylaw, that is not a criminal activity. That is a civil claim to which now you know they have no authority. If the municipality is claiming some violation of the bylaw, get a copy of the bylaw and to look and see what date or day it was signed. All too often, bylaws are passed first, second, and third reading on the same day, or the bylaw is not signed at all. In either case, this is not legal. Okay, and they can't attack a person for the same alleged crime twice. That's the double jeopardy rule, so even if they go fix their problem because they don't understand what they're doing, they can't bother you anyway. Read the bylaw, because oftentimes the bylaw enforcement make up things which are not even in the bylaw. This is true with Steve Heineman and a few other people who at one time worked at the City of Belleville. Read the statutes and apply it to the municipality. Okay, make sure what they're trying to say is legal, and as you now know, they have no right to pass any bylaw. It goes under their broad authority. Look that up in the Municipal Act, look that up in the Building Code, and you'll find what you need. Now here, If we look at this order or warrant, be sure it has a court file number. In this case, it has a court file number, and that's just one I pulled off the internet. And make sure it has the court seal, which this one does. And it's signed by a judge, because all too often they're not signed by a judge. Okay? They produce some BS document and attempt to commit fraud, and they convince you it's legal. And furthermore, if they try to show it to you on a phone or other electronic tablet, tell them you want the original certified copy from the court, and then you're willing to comply. This puts another roadblock in their path, because many times they'll take some fraudulent document and mix and match and paste it together, and it looks real, and you have the right to verify the validity of any document before you let them proceed. Also, if you are going to communicate with the municipality, or anyone else for that matter, in a legal issue, I would tell you to have them put all their correspondence in writing. When they don't, because most times they will not, they don't have the authority, and therefore when they go to put it in writing, it would be contradicting themselves or proving an act of fraud. When the municipality won't put it in writing, especially if they're instructed to do so, then they have no claim. I was dealing with Robert F. Scott out of the Belleville Court, and he told the municipality they could do an inspection on the property, which I can refuse, but I agreed to it. And when the municipality came out that day, literally within a half an hour, they would not put anything in writing, and as such they have no case. Now, if the judge wants to participate in an act of fraud and act as their defense lawyer, then I can tell the judge, which I did. I told her the buck stops here. You simply don't comply with their bullshit. It is unlikely you'll get help from any lawyer. I've contacted all the lawyers in Ontario, specifically ones that deal with municipal law, and as soon as they find out you're going against the corporation, they won't help you. Now, you must realize that the federal government gives jurisdiction to the provincial government, which gives jurisdiction to the municipal government. So if you go to a lawyer who's registered in the province, they would technically be attacking one of their own kind. So therefore they won't do it. If you do go to get help from a lawyer, they may or may not know what the law is. Yes, that's right. They may not know the law. I talked to all the lawyers in Ontario, and when I talked to one of them, they said the municipality had the authority. Once I sent them the paperwork to prove they don't, they wouldn't talk to me anymore. This is because I know the law better than they do. And as you guys have now seen, if you've watched any of my other videos, when I study the law, I study that law inside out and upside down. I present many things to deal with council tax, and now I'm getting into the municipal law for the province of Ontario. If you, like I say, are trying to get help, look for a lawyer that does municipal law, but I don't think you'll find any that'll help you. You may have to educate them on what the law is. This generally upsets them because they don't like taking orders and instructions from basically the peon, which is you. They think they're a lawyer, and they wear their suits and their brown shoes, and therefore they have the authority, and you shouldn't question what they tell you. Well, keep in mind that there's a conflict of interest because the lawyer is licensed by that province, and if they go against the system, they will lose their license, therefore their income, and potentially their pension. Can you take the municipality to court? Yes, you can. You can take them to court if you can prove that they are operating in bad faith under Section 272 and 273 of the Municipal Act. So if they pass some BS bylaw, the bylaws passed in good faith under the Act shall not be quashed or open to review in whole or in part by any court because of the unreasonableness or supposed unreasonableness of the bylaw. But it said a bylaw passed in good faith. Well, if you turn around and notify the municipality they have no right to pass that bylaw, and you can show them that they have no right to pass that bylaw, then they can no longer argue it was done in good faith. So you have every right then to take the municipality to court. Now, good luck getting a fair trial because the court system is corrupt. Application to quash a bylaw, Section 273. Upon application of any person to the Superior Court of Justice, may quash a bylaw of a municipality in whole or in part for illegality. Okay, and then it goes in a bylaw, includes, by the way, includes is restricted to an order or a resolution. Now, in the case of the municipality, if you want to bring a case against them, you are working also under the statute of limitations. Now, because the bylaw is passed fraudulently, especially if you've notified them before they do it, there is no exploration on fraud. Now, fraud is actually a criminal offense, and there is a way to launch a criminal case in Ontario. I was told by RCMP and a bunch of other people that it was not possible, but I actually found out it is possible, and the reason they don't want you to know this is because they would have to answer to criminal charges, which makes them no longer fit for duty or for their application where they work. Now, because we're talking about court, the potential of court, I had to educate the city lawyer on pretrial. So normally a person puts in a claim, then they put in a defense, and then we go to mediation. Now, mediation is mandatory in Toronto, Windsor, Ottawa, but it's recommended that you try to mediate because it looks good for you. Now, in the case of Toronto, Sean Dumphy, which was the the judge at the time, disregarded that fact, and therefore his case has no authority. Once the municipality lawyer broke the law, she also has no authority. And once you do your mediation, if you can't resolve your issues, then the matter is set down for trial. Okay, and then it's placed on the trial list, and it can be taken off the trial list, and it gives you the time frame. It's usually 190 days. Pre-trial is scheduled, then there's a pre-trial conference, and then you actually go to the pre-trial, and then the full trial if need be. So that's the general rule for civil court procedures. Okay, that's the ordinary procedure. There is two different ways to do this. Now, okay, is there a way to appeal the property order? Yes. You can go through the appeals process within your municipality. Going through the appeals process, however, creates a conflict of interest. And I'm talking this is before we go into trial. Okay? So if you get some bylaw officer who operates illegally, and so does the chief building official, because don't forget that the bylaw officer works for the chief building official, right? So they work under his or her directive. So you can go to the appeals process before this goes to trial, but going through the appeals process creates a conflict of interest, and the appeals committee has one task, and that is to uphold the corporate policy, which is a conflict of interest. If you can convince them that the municipality has no authority based on the letter you sent previously, you may or may not win. And then you either proceed further by going to actual court. But if you go down this road, remember that the judge's job is to uphold that of the municipal corporation. So there's a conflict here. You may wish to, before they pounce on you, take them to court. This is also a slippery slope, because now you have to pay all the upfront filing fees and everything else. But if you remember earlier, you have the right to quash any bylaw under Section 272 and 273, and you can investigate that and see if it's appropriate in your application. Okay? What's it going to do? It's going to have the powers of the committee. On appeal, the committee has all the powers and functions of the officer who made, and the committee may do the following things. If the committee's opinion, doing so would maintain the general intent and purpose of the bylaw, of the official plan or statement. So this is telling you now you're not going to get a fair trial. Simple as that. What if I lose the committee meeting? Now you are forced to go through the appeals process within your municipality. Going through the appeals process, however, creates a conflict of interest, as we've just pointed out, and the appeals court has its one task, and that is to uphold the committee's decision unless you can convince the court the municipality has no authority based on the law and the facts that the city is operating in bad faith. This is why this video presentation, you should take notes. Now, municipal's liability. Immunity. Section 448, no proceeding for damages otherwise shall be commenced against a member of council or an officer, employee, or agent of the municipality or person acting under their instruction of the officer, employee, or agent for any act done in good faith. Well, once you've notified the municipality that they're not operating within the confines of the law, they can no longer argue it's within good faith in performance or intent performance of a duty or authority under this act or bylaw passed under it for any alleged neglect or default in performance in good faith of the duty or authority. So again, you have to prove to the municipality in advance that they have no authority to do this. I was told I can't record my own court case. Okay, Sean Dunphy stated that, and many courts state the same thing. Sean Dunphy was is a unlawfully operating judge out of Toronto. Every person who appears before a court in the province of Ontario has the legal right to record his or her own court case. Okay, as long as you do it in an unobtrusive manner. The law is quite clear under Section 136, Sub 2B of the Ontario Courts of Justice Act. Citizens, which is you people, have the right to audio record their own court hearing. And many times when you try to get a transcript of the court, such as in Sean Dunphy's case, he actually sealed the court case. So now it makes it very hard for you to do an appeal. However, if you have your own court, your own audio recording, simply use that. Again, the judge is breaking the law, so now that he sealed the court case, which is illegal, and he wouldn't let a person file a defense, and in fact they had correspondence the day of the hearing, while a person waited in Zoom for about 15 minutes or so, which is called ex parte communications, which is again unlawful. So the city solicitor broke the law, and so did the judge. Therefore, Sean Dunphy and Jennifer Savini are breaking the law. Now, what if the court operates outside the law? If the court operates outside the law, then you must prove the violation within the law, and you can now have the case declared void. This would be an appeals process. Once that happens, the court loses jurisdiction permanently, and the persons involved are not protected from legal prosecution. They're not protected anyway, because the corporation took you to court. And the officers, if they're operating in good faith, are protected. But if they're operating in bad faith outside the statute, you can take them to court within the certain provisions of the statute of limitations, or in the case of a criminal prosecution, if it's fraud, it has no expiration date. No person shall be convicted of an offense in respect to an act or omission in obedience to the laws for the time being made and enforced by persons in de facto possession of the sovereign power in and over the place where the omission occurs. So if you are operating within confines of the law, and you accept the fact that you're a person, and there's a debate on that one, no person, that means, okay, you shall not be convicted of an offense in respect to an act or omission in obedience of the laws for the time being made and enforced by persons in de facto possession of the sovereign power. So if the municipality is trying to push some garbage on you, or if a police officer is trying to push some garbage on you, and you're operating within the confines of the law, they can't charge you anyway. So there's another solution to that problem. Now, who can represent me in courts? You can represent yourself. You're deemed to not be practicing law, and you're not providing a legal service, so the Law Society Act doesn't come down on you. Okay? Okay? You can provide, you're not practicing law or providing legal services if you give someone some advice. Okay? For the purpose of this act, the following persons shall be deemed not to be prescribing law or providing legal services: an individual who is acting on his or her own behalf, whether in relation to the document, proceeding, or otherwise. Therefore, you can represent yourself in court, and it's likely the only way you're going to get some sort of reasonable resemblance to actually following the law. Whether the courts will do it, whether the city lawyer will do it, well, that's another story. Now, who can represent me in court? There are situations you do not need a license to practice law or provide legal services. The Law Society Act states, under the interpretation, a person who is authorized to provide legal service means a person who is not a licensed but permitted to by the bylaw to provide legal services in Ontario. Exceptions: non-licensed practicing law or providing legal services. Section 26.1, sub 5. A person who is not licensed may practice law or provide legal services in Ontario if and to the extent permissible by the bylaws. And bylaws don't apply to you anyway. Section 26.1. A person who is not licensed may hold themselves out as the representatives themselves to be a person who may provide legal services in Ontario if, and I assume all these have to be met, the bylaw permits the person to provide legal services in Ontario, and the person specifies in the course of holding representation the restrictions, if any, on an area of law which the person is authorized to provide legal services, and the legal services that person is authorized to provide. So this is all a bunch of malarkey. None of it speaks actual plain English. So the solution to the matter is you can provide legal advice to someone, but it should be up to them to present their own case, because you can represent yourself in court. Based on the law of Society of Upper Canada, you are allowed to represent a friend or a neighbor or family member without a license, but you may also get railroaded because the judge may say no. Okay? So now that we've looked into the law, we find out providing legal services without a license. The following may, without a license, provide legal services in Ontario to anyone who holds the Class P1 license authorized to provide, acting for a friend or neighbor. Okay, so you can do this, and you guys can pause this and read through the rest of it. But they will try and tell you you can't do it, or they'll prevent you from doing it. And if you argue with the judge, then the judge holds you in contempt of court, and you've got a bigger problem. So basically, learn your own court case. Do it yourself. That way, if something goes wrong, you have yourself to blame and no one else. You can get somebody to act as a Mackenzie friend. They can go to court with you. They can help you find paperwork or point out where things are and hand paperwork to you as you call it out in your court case. My suggestion is put your stuff in a binder, know where all your stuff is, know your thing backwards, forwards, and upside down, so that if you have to argue your case, they can't pull any shenanigans on you and you're hunting looking for certain documents that you forgot at home or you can't find them because you're disorganized. Put your things in a binder, keep everything organized, and study the law, so if they try and pull shenanigans, you know what they can and cannot do. Okay, what if the municipality tries to add or add extra cost and stuff to my property? If the municipality tries to add the cost to clean up to your taxes, they're not allowed to do this. First, if they disposed of anything of yours, that's theft under the Criminal Code of Canada. Secondly, depending on what they took, it may have a salvage value, which could be used to offset the cleanup costs. Third, the municipality is not allowed to engage in any activity then mitigate costs. This falls under Section 17 of the Municipal Act. They're also not allowed to charge property taxes. Look up 17, I think it's 17.1 or 17A, whichever way they did it. Fourth, the municipality is not allowed to charge taxes in the first place. Kindly refer to Section 17 of the Municipal Act. Now, here's Section 17.1. Notice it says here Sections 9, 10, and 11. This is the municipality is limited by Sections 9, 10, and 11. 9, if you recall, was the natural person. 10 and 11 give them authority over public property and consumer protection. And it doesn't allow the city to impose taxes. Right there, 17.1 sub A. They can't impose taxes. Your property taxes that you've been paying are actually fraud. I would suggest everyone go to their local council and demand their taxes back. And then it says B, enter an agreement for the purpose of minimizing costs or financial risks associated with incurring of debt. Well, the municipality hired a lawyer, so they entered into an agreement for the purpose of minimizing costs and financial risk, because the lawyers are a member of the Bar Society and they will try and shaft you at any chance they get. Simple as that. That's illegal. And then they want you to pay the lawyer's fees, which they can't legally enter into that agreement in the first place. Now, if that's not fraud, I don't know what is. Final thoughts. If the municipality, including the police or municipality, tries to get you to do anything, ask them to show you the law which obligates you to do so, whatever it is that they're asking you to do. Remember that everything you do is a contract. No one can force you into a contract. You have a right to tell the police officers to take a hike because they have no jurisdiction on civil matters, and I've already proven that. If anyone tries to interact with you, say as little as possible or nothing at all, and be sure to record everything, either on video or on audio or both. Get the names and identifications of anyone who you interact with. If the police won't identify themselves, then you don't identify yourself, because we're all equal under the law, or at least we're supposed to be. And if they're trying to engage with you, that is technically called intercourse. Okay, don't take it the wrong way, but if they want to engage with you, then you have every right to know who you are speaking with. If they won't provide their name, you're under no obligation to do it either. Be sure to follow up with any interaction with a written letter of understanding, allowing the other side a chance to dispute the points you present within the letter and give them a time to respond. 10 to 15 days is reasonable. If you don't hear from them, then they've agreed to the statements you made within your letter, and then you can follow through accordingly. Most times they're so arrogant and ignorant they won't answer you, and so therefore you're under no obligation to do anything other than what you agreed to within your correspondence. If you don't agree with something and it comes up in a meeting, make sure you put that in the letter as well. I will be providing legal documents indicating all the laws that are applicable, protecting your property rights to the municipality for a fee of $150 Canadian. I will provide you limited phone support up to 30 minutes. I want everybody to take action, and if people aren't doing it because they don't comprehend what to do, well, this is no longer an excuse. If you hired a lawyer, it would be a heck of a lot more expensive, and a lawyer's not going to tell you what I've just told you. The process of learning this thing took me 29 years and countless hours in aggravation of research. Okay? Now that I know it, I want to share it, but my time should be worth something. Would you work for somebody for 29 years and give away your information for free? I'm not prepared to do that. So I thank you for taking the time to listen to this presentation. Hope you found it useful. If you wish to contact me, I can be reached at that email address. If you want to make a donation to my efforts, that's the same email address. It's connected to PayPal. And if you want to request help, indicate a time when we can set up a Zoom call. Zoom is a free program, if you're unfamiliar with it, where people can connect by phone or computer. And I have to pay for that service. So, again, I'm not going to do it for free. But I'll give you a roughly 30-minute consultation. It's usually a little bit more than that. And we'll take it from there. Thank you for listening to this presentation. Hope you found it useful. And good luck. Thank you.